All right. I think our numbers are going to continue to creep up as folks get back from lunch, meetings, drying themselves off, etc. So I'm going to welcome everyone to the latest in our FOIA Officer webinar training. Today is July 30th, 2025. I'm going to share my, let's see here, deck. Hopefully PowerPoint Live is my friend. All right, so welcome to DC FOIA best practices, including process and responses. This is going to be a bit of a comprehensive FOIA presentation, but the emphasis, because many of you have attended recurrently a lot of FOIA trainings, trying to mix it up a little bit, and also, quite honestly, to just emphasize some things that as big as FOIA officer I see regularly and get asked about in terms of giving FOIA officers advice. This is the statutory regime. We all know it. We all love it. 2-531 to 2-540 in the code. I'm going to kind of go at a fast clip today. I hope that's all right. My colleagues, Joan Lelma and Brandon Lewis, as well as the Director of Open Government, Nicole Allen, are all here with us and will be monitoring the chat. If you do have a question, please put it in the chat. If it's something you'd rather discuss with the group, then please save it to the end, and I'm happy to answer. Can I get a verbal from someone just confirming that they see the slide?
Yeah, can see it.
Great. Outstanding. Thank you all very much. Okay, so we're going to start off with top to bottom, big to small. We're going to talk about the agency and best practices first. So the responsibility for FOIA is also beyond what's codified at the statute, is also in the DC municipal regulations. So at 1 DCMR 4011, we're told the ultimate responsibility for responding to requests for records of an agency is vested in the agency head. Now, each agency shall designate an individual as the Freedom of Information Officer of the agency and may delegate to that individual the authority to grant and deny requests and to whatever. But right from the jump, we see something that a lot of people misunderstand, which is ultimate responsibility is the head of an agency. And although they can delegate, they can delegate the authority to grant and deny requests and designate an individual, that does not alleviate them ultimately of their responsibility. So it is an agency-wide, holistic expectation of FOIA, of DC FOIA, for the agency head, its officer, and all staff, we're going to talk about that in a minute, to be involved. So DC FOIA requires that district agencies proactively make public information available on the internet. If you're new as a FOIA officer, you may not have seen or received the email that I sent out, it must be 6 months now, letting all the agencies know that we were in fact going to be doing a proactive disclosure audit per DC Official Code 2-536. Information like information staff manuals, final opinions, policies, contract material, et cetera, are supposed to be listed on the agency's website, preferably under the FOIA or Open Government and FOIA tab. The district government has proactively released hundreds of data sets on opendata.dc.gov. So the government has long been in the practice of identifying things that need to be proactively disclosed, that have been requested repeatedly, put them into reading rooms, et cetera. And as I say, we're in the middle, heading into the final analysis stretch of a proactive disclosure audit. So I will be reaching out to individual FOIA officers based on what we found posted on agency websites. But this is a requirement for the agency itself. All of these things are things that are required without any FOIA request and have to be made available. Salary, title, and employment dates, that can just be a link to DCHR, contract expenditures, budgets, manuals, policies, rules, et cetera. And then meeting minutes of open proceedings of public bodies. This is one of those rare places where the OMA and DC FOIA intersect. A public body shall make available for inspection and copying any record produced or collected pursuant to a contract with a private contractor to perform a public function. And the public body with programmatic responsibility of the contractor shall be responsible for making such records available to the same extent as if the record were maintained by the public body. This is a responsibility of your contracting officers, your agency heads, et cetera, to make sure that you have access to the contractor's records when they are contracted to perform a public function. Now we're going to get down to the more specific, to the FOIA officers yourselves and personnel. The primary point of contact for DC FOIA is and should be the FOIA officer. According to 4013, each agency shall post the name, title, I'm sorry, I should have said that a copy of the presentation will be available on open-dc.gov, as well as a link to the recording on our YouTube page. Name, title, address, telephone number, fax number, and email. I'm going to go back up to name. This is something that we've discovered in the proactive disclosure audit. A FOIA officer of an agency must have their name, not FOIA officer, not something generic. Their name must be posted as the FOIA officer on the website of the public body. This is not negotiable. This is something I've had people push back on, and it's not something that is open to interpretation. The reg is very clear. If the person changes, then immediately someone else needs to be identified and specified, because the reg requires that either the agency head or their designee be acting as the person responsible. All FOI officers shall attend the meeting and training sessions. This has been superseded, this original regulation. We provide the training that satisfies this requirement. Lottie-dottie, and I think everybody knows that means everybody. All agency employees who maintain records shall assist the designated FOIA officer as appropriate with the identification and search of responsive records. If you get pushback, 4015 is what you show your fellow agency employees who say, not my job to locate or search or identify records. Absolutely not true. FOIA officer is the lead, but everybody in the agency has a responsibility to be FOIA compliant. Let's talk about process. These are, keep an eye open, keep on top of it. Here, insert your favorite cute metaphor here. This is my best advice. Know the rules. You've got all the decks that we do during these FOIA webinars. You've got the regs, you've got the statute, you've got other online resources. Monitor GovQA. I'm not saying that it's flawed, but what I'm saying is, if somebody doesn't have the right box clicked, if they don't have you to get an alert when the request comes in, et cetera, then a request to the agency may go unnoticed, and then you're into the scramble of, well, I never saw it, I didn't know, we're responding late, and it snowballs. Check your settings. Make sure that you are, or whoever needs to be, is the person that's going to get the email alert. You can designate multiple people, et cetera. Establish processes inside your office. This is part of what this training today is hopefully going to allow you to do. OOG, we are available to help you establish processes if need be. I talk to at least 3 to 5 FOIA officers a week, every week. Communicate with the staff. If it's needed, I'm happy to consult with a group of people to kind of give a mini training, et cetera, of people who maintain records in a given agency to make them understand what their roles and responsibilities are. Develop templates. If you don't already have an acknowledgement letter, determination letter, appeal letter, template, you need one. Identify roles. Identify whether it's you or your IT person that's going to put in the request to Octo. Communicate with the staff. Make sure everybody knows and understands the timelines. The key factor with identifying roles is, if somebody who maintains physical files, who has the only key, is going to be on vacation for 2 weeks, and you get a FOIA request, they're not back before you have to acknowledge and send a determination. Keep records. For the new FOIA officers, there is an annual reporting requirement where you have to submit a report that you're provided by the Office of the Secretary, but that documents the agency's FOIA activity for the year. And that gets published both by the mayor's office, and then another version gets published by OAG. And again, communicate with your staff. I've got that in there 3 different places because, again, if somebody else in your absence or because they're handling a confidential matter or privileged matter, they need to let you know when, in fact, they have handled a FOIA request so that you can keep track of it in terms of your log. Bear in mind, a public record could be any record anywhere. The term public record applies where the content's just prepared or used by a public body. Means of storage is immaterial. It doesn't matter whether it's on paper, a floppy disk from the old days, a hard drive, a cell phone. Government personnel cannot evade DC FOIA simply by preparing records on media they happen to own. And that comes from this case that is cited here, Competitive Enterprise Institute versus Office of Science and Technology Policy. We've also published multiple AOs that relate to and reference this concept. And by AO, I apologize, I mean advisory opinion. Under 2-532A, this is it. Any person has the right to inspect and at his discretion to copy any public record except as expressly provided by the FOIA exemptions, period. Unlike Virginia, when I say any, I mean any. In Virginia, a FOIA request, you have to be a Virginia resident domiciliary to request records. Under DC FOIA, any person includes non-residents, it includes corporate entities. We haven't determined yet or had a case that determines it, but it's probably going to also include AI-driven requests. And until there is a determination, I would advise you to process AI-driven requests if that's what you think they are, as if they were, normal standard FOIA requests. DCMR 402.3 does not require that the requester identify him or herself. In relevant part, the provision states a request shall include daytime telephone number, email address, or mailing address for the requester. And then, there's this FOIA appeal from 2017 that's referenced. The exceptions are when an individual requests records pertaining to him or herself and then has to have the ability to waive their privilege. But a requester can make an anonymous request that does have to be honored. Okay, there we go. All right, so at the beginning, you've received your request. We'll talk about acknowledgements. Your first step is an acknowledgement, which begins with an acknowledgement letter. The initial communication is an acknowledgement letter, and it shouldn't go out any later than 24 to 48 hours after receiving the FOIA request. If the FOIA request is received in the evening after normal business hours, you can treat it as being received the next morning, the next business morning. So if it's received at 8 p.m. after your tour of duty on a Friday night, you would treat receipt of it at open of business on Monday morning. Bear in mind, yes, I said develop a template, and I mean that. Nevertheless, the acknowledgement letter should address issues, all of them that are raised in the FOIA request. Acknowledgement letters have to include the following: the intro language, the acknowledgement date, the requester's personal information, the date the request was filed, the date the request was received, whatever your assigned FOIA reference request number is. It could be an internal number that you use, or it could be the number that is generated by the GovQA system. And this is a duplication between those 2 points. Request description should be quoted verbatim, and you'll see in the sample letter in a moment what I mean by that. You discuss fee classification of the request and discuss whether or not a fee waiver, if requested, would apply, and then the appeal process. So this is a sample. Say this came to me from Joe Schmo in Florida. Dear Mr. Schmo, OOG is in receipt of your DC FOIA request. Your request was received in our office on this date. The reference number assigned is the following. Please use this reference number when contacting us. This is particularly relevant when there is a requester or requesters who make multiple requests. Keeping track of the difference, you're really going to rely on that reference number. Now, I state you requested the following with a colon, and then jogged in, I quote, and I cut and paste literally verbatim what the requester asks for. So in this case, it was, I don't know if this is the right office reference, wanting a copy of all emails between John Doe using his dc.gov email and Joan Q. Public using her dc.gov email that mentions the Open Meetings Act. And then they say I'm a journalist and request a fee waiver because the article I'm working on regards public business and will benefit the general public. Can you send the data slash emails or send a link where I can access them? Thanks. So that's the full quote of what came in the request. Acknowledging it, we forwarded your request to the Office of the Chief Technology Officer, meaning to do an email search of the requested emails. You should expect to hear from us within a week. You don't have to give a date certain. You should give some sense. I say below, always pursuant to 2-532C1, we have 15 business days to respond to your FOIA request, and then pointing out that in unusual circumstances, agencies may extend the response time for an additional 10 business days, according to 2-532D. If you have questions regarding this, you may reach out to me at my email or at the phone number. Please have your FOIA reference number available when you contact our office. That's the bare minimum that you need in an acknowledgement letter. The acknowledgement letter should include the possible cost associated with the request. Now, you'll note I didn't acknowledge that in my letter because this was a journalist and it does conduct business. I determined that the only fees that were going to be involved were going to involve copying. They asked for a link, so there may not even have costs that are associated, and I probably would grant that waiver. If you are going to charge fees, bear in mind there is no fee to submit the FOIA request. There are, however, fees for searching, reviewing, and reproducing records, and they're based upon what's called the classification of the requester. And a FOIA requester can be charged fees even if the search doesn't locate responsive records or a particular exemption ends up applying to those records. So remember, acknowledge the amount the requester has agreed to pay. They may say, especially in GovQA, where they can specify, please notify me if the cost is going to exceed X and such amount. Inform the requester that you'll advise them of additional costs. I didn't do that in that acknowledgement letter, but I would if I thought costs were definitely going to be implicated. And then advise if a voluminous amount of information is requested, before you just make a determination, you want to contact the requester and ask them if they want to discuss narrowing the request. And we'll talk about communication and collaboration a little bit later. Under DC FOIA, you must determine the requester's fee category to ascertain what fees agencies may charge. There's 3 categories, and you'll find them at DCMR 408. So a public body can establish or collect fees not to exceed, this is important, the actual cost, searching, reviewing, redacting, and the document can be first without a charge where the public body determines that it's in the public interest. The 3 categories are commercial, education, non-commercial, science or research / media, and then if not A or B. So for commercial, you can charge search fees, duplication fees, and review fees. For Category B, which includes basically the public use or the public benefit, then you would charge the duplication fees. And if it's not A or B, then you would charge the search and duplication fees. If the requester doesn't seek a waiver or doesn't check the box on GovQA for the thing, then again, you need to let them know if the fees are implicated. You can also require of a requester advance payment when either the request is certainly going to exceed $250 or there is a record in either GovQA or with your agency of the requester failing to pay in the past based on FOIA request. And I know multiple other FOIA officers have actually been in this situation where we have stated that we require prepayment before we will proceed because. And, if anybody asks or if a member of the public asks you, fees are payable to the general fund, not to the agency. So again, just to remind, 3 categories. Category A, commercial use, search, duplication, review. Non-commercial, duplication costs if the agency chooses to apply it, and none of the uses are just limited to duplication and search costs. So they must recruit a statement describing how the records are going to be used. If you suspect that this is a commercial entity that's going to use it for commercial purpose and they state that they're a journalist, you want to drill down on that, or you may need to adjust your fee, your application of the fee schedule. But you can waive. Bear in mind, you have the discretion to waive when you believe that the case has been made, that there is a public benefit to waiving the fee. And your authority for that is under 408.9 in the regs. In terms of the response, bear in mind, the time keeps on ticking into the future. For records other than body-worn camera recordings, an agency has to respond within 15 business days, and I stated that in the sample acknowledgement letter. For body-worn camera recordings, and that is particular for NPD, but for any agency whose officers, investigators, et cetera, use body-worn camera recordings, then the agency has to respond within 25 business days. And, both of those are at 2-532. I mentioned in the acknowledgement letter that, there's a carve out in 532 for unusual circumstances. So in unusual circumstances, the agency can invoke the 10-day. And remember, if you don't respond timely to a FOIA request within the 10 days, so Aisha, I'm going to punt that one. I don't have guidance on the best way to calculate fees. I'm going to direct you to the reg where it gives very specific information about what is allowed. You calculate your hourly based on your annual salary, what your hourly search fee is, et cetera. But I can do offline, or we can do in the future if there's enough interest, we can do something shorter and more specific on fee calculation. But it's an involved little process, and it's fact specific. So I excluded it from this, but I take your point and I appreciate your question. So if you're going to not reply, it is a constructive denial, and it will be treated as such with if someone appeals. No problem. So let's talk about this, and if you recognize this reference, you either watch a lot of TV or you're old like me. But under FOIA, what are unusual circumstances? Well, in DC, unusual circumstances are located at 532 D2. The need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records demanded in a single request. As we have discussed in every FOIA training we've ever given or has been asked, DC does not have, I repeat, DC does not have a void for volume provision. So if it's 10 million records from the request, then we have to deal with 10 million records. That's an unusual circumstance because it is a voluminous amount of separate and distinct records. So you're in unusual territory with that. Or the need for consultation, which has to be conducted with all practicable speed with another public body having a substantial interest in the determination of the request. This happens more often than you might think, that multiple agencies are involved in a set of records or have shared interest in a set of records, and that consultation is going to require that additional 10 days. And again, as with response, body-worn camera recordings, if the agency has an inability to procure a vendor able to perform the redactions to the video within the 25-day time period under that section, then they, again, are in unusual territory, and they can, in fact, apply the extension. So there is no expedite provision. I mean, there is an expedite provision in federal FOIA. There is no such provision in DC FOIA. So if you get a request for expedition, I need this, it's an emergency, it's a crisis. You are not required to do anything other than process the request under normal FOIA timeframes and explain there is no expedited review under district law. That is not to say that you are prohibited from providing a response to an expedited request. You certainly are allowed to do that, but you are not required to do that. And neither the MOLC, Mayor's Office of Legal Counsel, nor Superior Court is going to, punish you for having done that. Let the requester know what you perceive your response time. Keep in touch with them. It's the 15 days and the 25 days for MPD on body worn. Again, it's just courtesy, and it just keeps people off your back if you keep them in the loop. I know that some of the FOIA officers on this call deal with a perpetual onslaught of high volume records, and it is virtually impossible to do that. All I advise is that you do the best that you can. This again is what you're going to face. The request to expedite, the processing request, they state or even demonstrate a compelling need, and they'll cite the federal FOIA. As I said, let's go back one or two. There is an expedite provision in FOIA. There's no such in DC. So unfortunately, you don't have to, and you don't, fortunately for us, but unfortunately, the federal created that and created the whole issue of, a compelling need or demonstrated need. And it does. It puts the fire on the gas, unfortunately. This is a screenshot of the main page at GovQA. Agencies often ask the requester on their website, please use the portal for submitting all FOIA requests. It's the quickest method to get a response. And that's fine to say please, and asking them to use the portal to encourage that. However, while using the FOIA portal may be the simplest and best means, an agency may not require submission through the portal. The public has the right under FOIA, under DC FOIA, to make the request. So under the regs, a request can be made orally, it can be mailed, faxed, or emailed. And note that for emails, faxes, and snail mail requests, it does have to state FOIA request on the subject line of the email or on the envelope. But if a requester wants to make a request over the phone and they get you on the phone, or they get a staff member on the phone and they describe within the confines of the statute their request, that's a FOIA request. And an agency does not have any discretion, with one exception, and that's OAG. And I suspect that OAG's FOIA officer is with us today. And if not, she's aware. But unless agreed to in advance and confirmed in writing by the office's Freedom of Information Officer or the Chief Deputy Attorney General, a request for record shall be made in writing. That's in the regs for OAG. As far as I know, no other agency within the regs has that exemption. Let's talk a little bit about search. So you've done your search, you've made your request. If it's emails, the ESR request to Octo, you've searched your hard drive, you've had your colleagues search hard copy and electronic files, etc. You get your results, and you know what your request is. 2-534, I get random emails or phone calls. Is it okay if I redact the following? And I say, well, did you check 2-534? No, I wasn't sure if any of that would apply. Okay, well, please check 2-534 first, because again, it gives you all of the exemptions. Trade secrets and commercial or financial information from outside the government, unless substantial harm would occur. Personal privacy, body-worn camera recordings, investigatory records for law enforcement, including counsel investigations and Office of Police complaints, and then there's the qualifications to that explain under 3 what is and is not included, or what would or would not be excluded. Then you've got exemption 4, which takes in the common law privileges, attorney work product and deliberative process. Obviously, attorney-client privilege also applies. And then, you know, the future examination test questions, things other statutes, can't be a regulation, national security matters, antitrust, arson, emergency response plans, which again, uh, there have been changes to the statute in the last couple of years to shore up public infrastructure, safety and security, and emergency response plans, Social Security and federal employee ID number, whistleblowers, Homeland Security, sealed criminal, critical infrastructure, again, only to entities regulated by the PSC, teacher evaluations, private vehicles for hire, uh, records of the clemency board, and then the unclaimed property administrator. Um, that's a lot. There are a lot of exemptions. A lot of them won't apply to your given agency. So you really just need to become very familiar with the 2-534s that are related to you. They'll become your best friends. As I said before, you need to be in communication with the requester. Like it or not, the FOIA process is a collaborative effort. It's a collaborative effort between requester and FOIA officer. It's a collaborative effort between FOIA officer and agency and personnel. And communication may result in cooperation. Now, if you recognize this, where'd it go? There we go. Then you may just be as old as I am. For those not old enough, that's the electric company from back in the day, and two people can make FOIA work together. So that's the end of the cute portion of my presentation today. So the court specifically in FOP versus District of Columbia literally said in a 2016 decision, FOIA requester and district entity receiving requests are not or should not be in an inherently adversarial relationship. Now, I can hear the laughing. I can hear all of you behind your muted microphones laughing. This judge probably has never been in a FOIA request scenario. It becomes adversarial. It's incumbent upon us to work as diligently as possible to mitigate that and to de-escalate the adversarial nature of the relationship. Most FOIA requesters have sincere reasons for requesting the records. Some of them it's bad actors, some of them are reasons we may not agree with, but we should work to communicate, collaborate, clarify, and get the maximum amount of cooperation. And if for no other reason, because the judge said so. Now, this is where we get into the fine tuning of, is the requester being reasonable? The request has to reasonably describe the desired records with specifics. When it's their request is not sufficient to ID, then you should toll the request and ask them to supplement the request with the necessary information. If you can't if you can't locate a record from the information supplied, then you let the requester know. And then finally, under 4056, when the FOIA officer contacts the requester for additional information, request is deemed received when the additional information comes in. So you stop, you clarify. When the new information comes in, you start the clock over or the calendar over. Redaction. Again, I get the 2-534 questions. 2-534B allows for release of records by concealing the exempt portions from public view. Justification for the deletion, meaning the blacked out space, the redacted space, has to be explained fully in writing, and the extent of the deletion must be indicated on the portion of the record. If technically feasible, the extent of the deletion and specific exemptions shall be indicated at the place in the record where the deletion was made. For example, with a Word document, this can be done with comments. You can highlight the section once it's been redacted, and you can extend a comment out. You can put the provision under 2-534 and cite specifically what the reason was for the exemption and the redaction. We get this. This is one of these questions that I included because this comes in If not every week, then every other week. They get a request that says, I want the information in, I say here, an Excel spreadsheet. It could be a PDF, it could be a hologram, it could be a fever dream. It doesn't matter, because at the end of the day, the agency, if it does not, and this is from one of our quiz presentations, the agency does not keep the requested information in spreadsheet form. So the FOIA officer should create a spreadsheet for the requester, supply records in the form the agency maintains, or send records to a third party that can create the timesheet, the time to create the spreadsheet. And obviously the answer to that is DC FOIA does not require an agency to create documents or opinions in response to an individual's request for information or to obtain records for another agency, nor does an agency have to respond to questions designed as a FOIA request. I see a hand up. I'll pause for that in just a second. So under Dugan, versus DOJ for federal FOIA, it was established that, FOIA does not require, and where federal and DC FOIA are the same, we apply the federal law in the absence of local district precedent, does not require an agency to create documents. So if you have the material in a Word document, you don't have to create an Excel spreadsheet in response to the requester. They can either get it in the Word document or not get it at all, or they can do the conversion once they get the documentation. If I get a request for OAG records, and they're not records that I even have a copy of, I am not required to obtain those records for the requester. Requesters will contact your agency trying to make an end run around another agency's FOIA officer by trying to get you to do their legwork and seek the records of another agency. That is not okay, and that is not required. And phishing to try to determine if something exists, or phishing to try to determine if something is true or false, i.e. questions disguised as a FOIA request, do not per se have to be honored. Now, I can't see names, but I see a hand up. So Tanya, if you want to.
Yes. Hi, this is Tanya with DHCD. I was told years ago that, yes, we're not required to create documents. However, if the information is easily accessible, like just hidden print for a report, that we are supposed to do that.
When you say just hitting print, yeah, printing is
No,
not creating a new
not
record.
just hidden print, but if the data or information is in a database, then we can select because we have the information, so yeah, and we can just select to just print a report.
Right.
It's still kind of sort of creating a document, but it still answers the FOIA request.
But what you've also just done is created a new record. So that's fine. And you're not forbidden from doing what you just said. But what you've now done is created that record in a second format, which makes it a new record. So if you have structured data in a database, and then you put it into a report form from that, you're allowed to do that. But that is now a record. The record you provide the requester is now a new record that your agency possesses. And if there's no time lost and it's no frustration to you, all I'm saying is that DC FOIA does not require you to. You are allowed to create something that is more user-friendly. But if you have massive amounts of structured data and there is no easy report function, you are allowed simply to provide that requester with the structured data and let them deal with creating a report from it. But okay, by all means, you're not prohibited from doing that. Although bear in mind, you need to think through what are the after effects or what are the follow-on effects of creating additional records. For example, you may end up needing to put records into a reading room if they're requested multiple times, if that makes sense. Mm-hmm. Okay, great, thank you. Great point, and I appreciate the question. I will take this moment just to see from my colleagues, Brandon and Joan, do we have any questions in the chat, which I cannot see, except for the very brief second that it pops up, that need to be addressed?
Yes, Anthony, there is one I was typing, but since you asked, I'll just go ahead and read it to you if you'd like to respond. Sure. So Joseph has asked, his statement is, Although oral requests may be honored, a requester may be asked to submit in writing a request for records, and that's coding from DCMR. OOG's website also states that agencies can request that the FOIA request be submitted in writing. It doesn't indicate that this only applies to OAG. Can we get clarification on this?
Well, the director is on, but my understanding is, again, there's nothing that says, and this goes back to collaboration and communication. If it's a complicated or legally problematic FOIA request, there's nothing that says that a FOIA officer can't ask, can the requester put the request in writing, especially if the request is voluminous or has a lot of parameters. My interpretation of the reg that I cited, however, is if a requester insists on strictly an oral request, my reading of that is that it can't be denied. I don't know how often that extreme is going to be encountered, but Director, do you have any further?
Yeah, thanks for that. So what I would suggest you do in this situation is memorialize the request. I'm not sure if you can come on, Joseph, if you don't mind, and kind of give some more information about the oral request. But as far as submission, I could just say no. It's not something like Anthony said that you can't deny it. But you can yourself memorialize it. You can write it down. You can take notes on it and put it in the FOIA system. So is this a situation? I mean, you could put it in the chat too. I don't want to put you on the spot to get on camera. But if you could give us just more details, it would help to clarify kind of your situation and what you're seeking information on. But you don't have to. So seeing none, I assume you're satisfied with our answer. So I'll let you move on, Anthony. Thank you.
I will. And one other point, bear in mind, if you do get a telephone, for example, request, as long as you get the required consent, you can in fact record the call as long as the consent is part of the recording, and then transcribe that or memorialize it as the director says. You just have to make sure that you follow the law as far as the recording. Okay, so I'm going to pick up from there, and if we do get further on that, we'll circle back at the end and close out that question. This again comes from one of my colleagues who's no longer with us, presentation. Gone, up in smoke. A few records contained solely on an external hard drive were destroyed by a small office fire, and it caused the hard drive to explode. Does the FOIA officer who receives a FOIA submission requesting copies of some of the destroyed documents have to recreate them? You do not have to create records, which takes us back a moment to an aspect of what I said before. There is no obligation or DC FOIA to create records that don't exist. Find this at 407.3. If a requested record is known to have been destroyed or otherwise disposed of, and this includes things that have gone outside of the retention period, depending on the retention schedule for your agency's records, the requester shall be so notified. Not everybody's happy about the retention policy. Some people think that every document, every record should be maintained into infinity and beyond. Another pop culture reference. Unfortunately, that's not the way it is. And again, if you don't have the record, you don't have the record, but you do need to make the requester aware of that fact. Okay, so you've done your searches, you've done your exemption analysis, you've performed your redactions, you have determined that some records don't exist because they no longer exist, and that some records, or part of the request is, and ask to create records that don't exist. So you've determined all of your responses. Let's get into the actual act of responding. So, much like an acknowledgement letter, a decision letter has key aspects. In the final response to the requester, you need to know whether the record is released in full, partially, or withheld in full. Discuss the fees where it's applicable, and then a final response denying records should include the following things: the identity of each person responsible for the denial. In most cases, and Allison, I see your hand, so I'll acknowledge you in just a moment.
That was
response
a
to the
mistake.
denial.
I'm sorry.
Okay, no problem. If different than the person signing the letter. 9 times out of 10, for my agency, for example, I'm the one that made the decision on a denial. So I'm signing the letter, therefore I don't need to indicate anybody else. A reference to the specific exemption or exemptions, I mentioned that before. You should indicate at the point of redaction or in the absence of a record what exemption specifically is applied in each case. And then a reference to the code provision at 2-534, under the case law, if it's based instead of statute or reg, what that reference is. And then if the requested record can't be located or has been destroyed or otherwise disposed of, then you need to notify the requester. As I've said, communicating and collaborating is key. And again, DCMR 407 is where you find these provisions. So much like the sample acknowledgement, via electronic mail, I always attach a PDF, but I always include the language in both the body of the email and an attached PDF. It still has the contact information. It still has the reference number. It basically says, is in receipt of your thing, your request was received, and the number, instead of saying the number is the following, your request was assigned this number. I still leave in what was requested. Now's where it gets a little different. This is the determination. Upon review of your request, the undersigned, me, from, Vega has determined that there are no responsive records maintained by Vega. If for any reason you disagree with this finding, you may submit an administrative appeal to the mayor via the District of Columbia Government Freedom of Information Act public access website and there's the GovQA, by logging in with username and password. An appeal may also be submitted by mail or email. You can submit the appeal via email to FOIA Appeals at the MOLC or by snail mail to the Mayor's Office of Legal Counsel at this address. And then you tell them an appeal has to include a copy of the original request as well as a copy of the public body's written denial letter issued to you, if any. In addition, appeal must include a written statement of the arguments, circumstances, or reasons in support of the information sought by your request. Appeal letter must include Freedom of Information Act appeal or FOIA appeal in the subject line of the letter, as well as marked on the outside of the envelope. A copy of the appeal must also be provided to the public body whose denial you're appealing. So an appeal of one of my denials would come, a copy of the appeal would come to me when it goes to the MOLC. And then I gave an example in this case, and obviously based on the acknowledgement, the hypothetical that I did, I just pulled out agencies. Either the Department of Buildings or the DC Fire and Emergency Management Service are the DC agencies that would handle this DC FOIA request. DOB's FOIA information is here, and by here and here I have links. The FOIA request information in Fire and Emergency Management Service is here. If I determine that they just simply do not have a clue, and if they don't have a clue, 85–90% of the time it's coming to me, because we're the Office of Open Government. People assume that we handle all, because in some jurisdictions, the open government body handles all FOIA requests. So I move them or direct them on to the people if it's clear. Now, if, in the case of this, in the hypothetical, if it had been clear that it was either a fire inspection or a building permit thing, I'd send them to DOB and fire. I don't have to, but we try to provide maximum transparency, and we try to provide the best contacts possible to requesters. Again, you're not required to take that additional step, but I think it's best practice. Please remember to not ignore a request. If a request is not processed within time limit, you need to let the requester know why it was delayed, the date when they can expect a determination, the right to treat the delay as a denial and then appeal, even though you intend to act on it. They still have the right to appeal timely once they've been constructively denied. And you can ask the requester to forego appeal until a determination is made. That's in the reg. but they're not required to honor that request. So please just do not procrastinate. And I know it's hard, and I know we're all overwhelmed in these trying times, but the best advice, best practice in some cases is simply to get on it. If you're going to do a denial specifically, as opposed to say, I had said in my sample letter that there were no requests. As I mentioned before, I'm just reiterating, the denial has to include specific reasons, including citations to 2-534, your name in the letter, but anybody else's name if somebody was responsible for withholding and decision to deny, and notification of their judicial and administrative appeal rights. Now, the boilerplate that you'll have in the deck from my letter, for example, you can copy that. I mean, there's nothing wrong with the boilerplate that we're using. Just remember to include that. The requester who receives the letter of denial, this is the and/or is the key thing. We all know this. I've mentioned it already. They may file an administrative appeal with the MOLC, and/or they can file suit for relief in DC Superior Court, or they can do one and then the other, meaning the MOLC and then Superior Court. That is provided for in the DC FOIA comprehensive law between the statutes, the regs, and the precedents. Appeals, your response has to happen within 5 days, excluding weekends or legal holidays, of the receipt of an administrative FOIA repeal. This is not when you get a copy from the requester. This is when you get a copy from, or when you get notified from the MOLC that they have received an appeal. It probably isn't going to be a big time difference, but bear in mind that that's a distinction worth noting. You can request additional time filing a written or emailed request to the requester within 5 days, within those 5 days. But failure, just like failure under an acknowledgement and determination, failure to respond within the 5-day period or after an extension has been granted constitutes a waiver of the right to respond to the appeal. And therefore, the body, whether it's the MOLC or Superior Court, can respond any way that they choose and don't have to give you additional time to address the appeal. I mentioned this earlier. For your record keeping, on or before February 1st of each year, the mayor shall request from each body and submit to the council a report covering public record disclosure activity of each public body. The secretary's office will send you each year the report, give you instructions on how to fill it out. If you diligently maintained your records, it will take you maybe half a day to get through. If you have massive records, or if you have not, you're going to be spending your Christmas holiday meeting the deadline, because it's usually in December that comes from the secretary's office. And then OAG also submits an annual report regarding. So just bear in mind, the better records you keep, the better off you'll be come the end of the year at deadline time. I've included a couple of, and I see there are some questions. I'm going to wrap up and then get to the questions. Additional sources for interpreting DC FOIA and processing requests. There's a link here in the deck to the regs. They're 1 DCMR section 400 at SEEK. The MOLC opinions, the ones that have been published thus far, are on the MOLC's Freedom of Information Appeals page. Case law, bear in mind, federal FOIA case law is instructive. It is not binding. You can see the case DC versus FOP, Metro Police Labor Commission, regarding that. It's an interesting case to read. Our advisory opinions are all posted on open-dc.gov, as will this training. The link to the recording and the copy of the deck will be posted under documents and training on open-dc, I hope before the end of the day. If not, then by first thing in the morning. There's the DOJ guidance, which again is instructive and highly useful, especially where DC guidance is lacking. And then the federal government has what's called the Office of Government Information Services via the National Archives. At least they do for now. With the way things are changing in the federal government and the way a lot is being handled, we've already seen one major
They'll stay outside, Gigi said. That's got to be a health code violation.
Sorry.
Somebody's got an open mic. No problem. I don't know if the health code violation is probably me sweating to death here in DC today, like everybody else. We've got 2 more upcoming FOIA officer webinars in the series. Next week, our chief counsel, Louis Neal, is going to be talking about an advisory opinion review. I mentioned that our advisory opinions are posted on open-dc.gov. Chief counsel Neal is going to do a roundup, an explanation of the FOIA advisory opinions. And then the week following, on the 13th, Brendan Heath and Adam Daniel, our good friends from Civil Litigation Division at OAG, are going to be presenting on preparing a civil case and defensive litigation. And then there's going to be a Q&A on the topic moderated by the director, who you heard from earlier, Nicole Allen. That's an excellent presentation every year. And if your agency has been or expects to be involved in any level of defensive FOIA litigation, that's really one not to miss, for sure. An excellent presentation. And quite frankly, as will the advisory opinion review by Chief Counsel Neal. The prior presentations are posted on Open-DC under Documents and Training, so you can access them there. This is all of our contact information here at OOG. The director, chief counsel, myself and my colleagues, our paralegal specialist, and our IT specialist. If when in doubt, you're not sure who to contact, you can always reach out to our main inbox via the website at opengovoffice@dc.gov, or you can reach out to one of us. If you don't know who else to reach out to, feel free to reach out to me and I will get your request either handled or I'll get it to the right person. I'm going to now take whatever remaining questions there are. I know a few hands went up mistakenly, etc. But if there are any unresolved or unasked questions, now's your chance. And I'll ask my colleagues again, have we identified anybody who maybe doesn't want to come off mute but has a question that we haven't addressed? All right.
Hey,
Hearing
Anthony,
none.
Sorry, Anthony, I think there's actually 2 questions in the chat. One from Aisha. Is there a consideration to revise the code to require a time frame for requester to file an appeal? It's my understanding that the current statute is silent on this point.
The statute is silent.
So I know that we have 5 days to respond once we get the MULC, the MULC's information that we need to file and respond to an appeal. But we had a case where, we provided our response, not our response to their appeal, but provided our initial response to the requester. They waited like 4 or 5 months and then appealed it. It's my understanding that there's no time frame for when they need to file that appeal. And I do think that revising the code to add that additional language, like you have 10 days or 30 days or whatever, would provide a little bit more structure around this process. But if I'm wrong about that, please let me know what the time frame is.
So it's an interesting question. And in prior webinar, as part of this series, we've had other statutory questions come up about what may be in the works to revise or possibly to be advocated. I'm going to leave that again and punt in case the director wants to weigh in. We've long advocated for a task force to look at both open meeting and FOIA provisions and bring things into sort of the new reality of the 21st century post-pandemic period. I don't think we're opposed to entertaining any particular discussion. I'm not aware of any move to change it to create a closed end to the appeal window. And if anybody else knows something different, please feel free to speak freely.
I'll make a comment. This is Director Allen. So once taking it out of the MULC process, there is a litigation process which is separate, and those timeframes are set up by statute. So whenever you sue, and the OAG folks will get more into this, but whenever you sue the district, you have to give 6 months notice before you file a complaint, et cetera. So requesters have that kind of baked in if they want to sue the district or for not processing FOIA. But yes, as far as the MOLT goes, we have issued an advisory opinion. I've spoke before the council requesting that we revise all the timeframes. They're not realistic. We generally can't meet them. And, I do get your point about kind of there should be a time limit on the administrative appeal portion of it. But it's not a time limit because we would prefer that they take the administrative route versus we as the government versus going to court and filing a civil action against the district. But the entity, so to speak, that's responsible for recommending changes to the council to where they would be implemented is the mayor through her legal counsel. So, certainly as part of an agency, you can let Betsy Cavendish know about these concerns, and that office is responsible for FOIA regulations and things of that nature. And that's kind of, to me, if you want something done quickly, would be for the issuance of a new regulation around it. But that would only apply to agencies under her authority. But I take that point, and as this office, VEGA, makes recommendations to other government entities, we'll add that to our ongoing list of adjustments that need to be made. But we hear you and thank you for raising that issue.
Thank you.
Absolutely. Thank you. And Brandon, I believe you said there were 2 questions. Do we know what the other one is?
Joseph had a question. If your agency receives a FOIA request and the agency no longer maintains those records, but the records do exist, is it the responsibility of the agency to acknowledge that the records do exist to the requester? Or is it the response just to say the agency does not maintain those records?
Wow. Somebody y'all put on your thinking caps today to try to puzzle the overheated old attorney. That's an interesting question. I mean, it's probably not novel in the sense that I'm sure it's been addressed somewhere. In and of itself, the FOIA officer for the agency is responsible for FOIA requests to their agency and records that the agency maintains. If for some reason that agency no longer maintains those records, now that does not mean they've gone to the archives, for example. That is still, to one degree or another, your responsibility to sort of quarterback. However, if for some reason, say under the old it became Department of Buildings and the other entity, DCRA, then in that split, I could see where records that used to be the province of one became the province of another, for example. My recommendation would be direct them to the right place. They're entitled to the record, no matter where it happens to be located, but it doesn't become, beyond that, it does not become your responsibility. You can let them know the records exist and where they likely are and direct them to the right person. I would say that is due diligence and best practice. Beyond that, you don't have to have a role. There's nothing in the statute or the regulations that require you performing any other function. Does that answer the question? Great. Very good. Thank you. All right. I appreciate you all. We got it done in just about exactly an hour, which is always the goal if I can make it happen. I hope everyone stays cool, has a great rest of their day. And again, we're here not just for the FOIA webinars. We're here anytime you all need us. Feel free to reach out for advice or information. As I stated, the deck and the recording will be linked and the deck will be up on Open-DC. I'm confident before the end of today. And And we really appreciate you all, and we hope to see you again soon.